The next matter to come before the court this morning is State of Ohio versus Prentice L. Smith. Both sides will have 15 minutes to argue. The appellant will reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, please let me know as we started. You can also keep track of the time on the clock on the wall. Please don't use the names of any victims or minors. We are recording. This will be posted on the court's YouTube channel. We've read the briefs. We're ready to proceed when you are.
Good morning, Judge Hensel, Judge Lansinger, Judge Stevenson, Attorney DiMartino. May it please the court, I am Richard Kudachief. I am court-appointed counsel for this appeal, and I look forward to advancing to this court important, not only factual basis, but persuasion, because this court has a very important opportunity to talk about two important issues. First of all, speedy trial. Second of all, severance issues. The issue of manifest weight I'm going to leave more so to this court's reading of the brief. I think it's sufficiently well outlined, and 15 minutes doesn't give us too much time. Also, I'm going to talk very briefly about consecutive sentences. But what we have here is an indictment from May of 2019 relative to 4 different events. And significant also is the fact that this case didn't go to trial for 2 years. So then, if we look at the nature of the claim in the indictment, we have a 10-year period of time from 2011 with VG, who was the claimed victim. We have then March 2015, May 2015, and December 2018 with 3 other named individual victims. The distinction is critical because when you look at the factual basis, we have a very important distinction in VG. We have, in the later 3 cases, we have your garden variety classic rapes and kidnappings that we lawyers and judges deal with, where an individual is kidnapped and then a sexual assault occurs. In this instance, in those 3 events, we have the Mr. Smith claiming to have driven his vehicle after bringing this individual into his car and parking that car next to a wall and then committing a rape. Those factual bases are very similar in those 3 cases, but when we look at VG, we have a very distinct factual basis that is critical when analysis is made here, because there is no similarity between VG's case, where the rape occurred in a field, in the back seat. She removed one pant leg, and I'll get to that here in a little bit. So by the way, I'm going to reserve 3 minutes if I may. We have in the record a time waiver from, it looks like September of 19 to maybe February of 20th. We have a motion to sever, we have a motion to suppress, and we have a motion to dismiss. We have a sentence with consecutive terms adding up to 81 years. Prentice Smith is a 43-year-old individual at the date of this arrest. He came to the court with a modest history. He has 3 daughters. He has a Bachelor of Arts degree in social work from Akron, University of Akron, all gainfully employed.
But could you move on to the speedy trial question, if you would? Are you asserting that the time during the Supreme Court's tolling of trials from roughly March to July of 2020, are you asserting that is that did not toll, or do you agree that would have tolled the speedy trial statute during that time?
Well, if you look at the briefing, because the complexity of how this all plays out and the confusion of all this, how this plays out, is questionably whether it's argued or not in the brief. Okay, I think that as the government pointed out, that issue was not raised in this brief.
Okay.
Now, having said that,
how about then for the period after?
I'm sorry?
The period's controlled by Judge McCarty's decision from July to October. Her specific continuances with the administrative order that occurred.
That's
Do
true.
you believe that Judge McCarty did not specifically find that there was cause for continuance?
Oh, most definitely, the record clearly demonstrates, I'm going to get to that more specifically in a second.
Please do now.
Well, if you take a look at, so let's talk about September continuance, okay? We have conversation, and the predicate for all of the tolling topics or all of the speedy trial issue is from the continual objection by the defendant of continuances. And not only that, we have 2 motions to dismiss. So if you take a look at what happens in September, so let's get to August, we get to now continuance, and September comes along. The distinction of the journal entry and what actually went down is of critical importance. So I know we're going to say, well, we have the journal entry, it speaks for itself, and the journal entry is what controls. But that's not fair here, because if you look, I don't know why defense counsel did not deal with that journal entry. The matter, if you look at the transcript, and I asked you to look at it here, the transcript is clear that it was over defense objection. And even though the journal entry did not say that, we still have the judge herself saying there is no, the time is running. There's no tolling. Judge McCarty says that herself in here. Now, again, why the journal
That's in
entry?
your journal entry, counsel, or that in the transcript that she said?
That is in the transcript, Your Honor. It is not in the journal entry.
Thank you, I just want to make sure I understood that.
Well, that's critical here. It's critical here. So what are we going to say? Well, the journal entry controls. Well, that's not fair. I think this court has the ability to look at the basis for that journal entry. I don't know why it wasn't argued, why counsel did not, look through that and amend that. Because it's critical. It says in the journal entry that the continuance happened by agreement of the parties. That's not
Does
right.
the judge also include the administrative orders about jury trials in all of those motions?
There is conversation there about the order indeed, and that's part of what we're getting to. I mean, let's talk speedy trial here. Is there ever a speedy trial violation? Well, take a look at all the nuances on speedy trial arguments. You can do this. So the defense lawyer files a motion for discovery, and the state doesn't give, the discovery for a while. Well, okay. And then, we file a motion to suppress and whatnot. So those are exceptions. But, and you're probably saying, well, you're asking us to dismiss, 4 rapes here. Come on, what are you really talking about? And I'm not asking you to dismiss that. The United States Constitution, the Constitution of Ohio, case law, as well as 294571 is asking you to do that.
Would you agree that the judge is unavailable if her administrative judge is not allowing her to have a jury trial?
No, I believe the record demonstrates that there was a visiting judge available at that time. Now, again, the issue of MO 700 was not raised here. That, I believe, however, can be viewed as inclusive in our argument of what constitutes a violation of speedy trial. So, we want to blame everything on the pandemic, on COVID. Where does COVID end? And the Constitution begin? And that's partially what this argument...
Did the administrative order, MO 700, whatever it was, does it specifically say the speedy trial statute is told, or does it just say we won't try unless you're within 1 or 2 weeks of trial deadline?
Yes, Your Honor, surely. And you know what? The confusion and confliction on all of that is still going on today, by the way. But having said that, I don't know how to interpret that, and it's interpreted by my predecessor in the brief, and I think that's how we advance here. Where is the 14 days? Where is the 7 days? If you look at the record, the trial court had an obligation to secure a timely trial, and it didn't fulfill those obligations. Yes, if you look at the transcript, look at the ruling on the motions to dismiss, there's, what we may call legal confliction or legal, I don't know what, but it's a standard that needs to be looked at when talking about sui sponte continuances. And that's part of all of this that is going on as well. If you look at the requirement for specific trial violation when we're looking at a standard of review here, which is a de novo review, by the way, as you know. Prentice was deprived of his constitutional right to a speedy trial. Again, I ask, when will we have a speedy trial violation in our lives? Because when you look at case law, there are so many exceptions, distinctions. And the exceptions here, this fundamental constitutional guarantee, and look at 2945-71 violations. Yes.
Two type of violations. One is the statute, 2945-71, whatever you said. That violation to me isn't necessarily prejudicial. You're in for more than 270 days go by, don't have to show prejudice, that's a violation, period. Where the second part of it is, the constitutional one, you have to show some prejudice to your client for a speedy trial violation. So outside the statutory, what is the prejudicial effect on your client in this case? What if you lose by the trial being delayed as long as it was, as far as testimony or otherwise?
Well, I'm glad you asked that question, Your Honor, except the distinction of prejudice does not go along with a constitutional requirement for speedy trial. Okay, prejudice has to do some of these other things I'm going to talk about real quickly here, but if you take a look at our argument, and as you look at the different continuances sui sponte made, then you'll see the trial judge saying, I can't toll time against the defendant when when the judge is allowing trials. So let's ask ourselves, lawyers, now judges, what is fair here? And how long are we going to continually sui sponte? So when this court rules on the topic of COVID pandemic continuances, in the same breath take a look at the fairness and what's involved with the Constitution of the United States of America. The confusing and unclear nature is really a distinction in this, for all of us, a major event in our legal careers and legal times. In conclusion on this topic, there is no issue of defense being unavailable in the big pictures. There's no outstanding motions. There's no other time trial concerns. The courthouse was not closed. So all of these things demonstrate that there was not necessarily an unreasonable reason for continuance, but the sui sponte continuances were unreasonable. I'm running out of time. Let me talk about severance really quickly, because we have these 10 years of time. We have a gun in the BG case, and that distinction is critical. If you ask, well, how does this defense prove this? Well, the defense doesn't prove it, but proof is self-evident, because the prejudice in proof is there similar character? No. Same actor transaction? No. Connected together? No. Common scheme or plan? No. So Rule 14 and the limitations, the trial evidence shows otherwise relative to other acts. And I think when you look at the big picture, it is not speculation as to how this prejudice is shown. I mean, come on, it's obvious. Even I'm a little, when I'm looking at this record, I'm like, well, wait a minute, she got a gun and pointed at her, and what is that? How's that other acts relative to picking up a prostitute, putting her in the car, in the front seat, having sex with her, with the passenger side up against the wall, versus picking up a prostitute with a gun, taking it to a field and raping her in the back seat. Those are distinctions, and that is why a severance should have concerned the court more than it did. If you look at the court order relative to severance, it dwells on other acts. So I don't know if I have any time left or not for rebuttal, or
You'll have a minute for rebuttal.
a minute?
You'll have just over a minute for rebuttal.
Well, that should be plenty of time to rebut a marvelous argument from that. Thank you, Honor.
May it please the court, Evan D. Martino on behalf of the state of Ohio, the appellee. I apologize in advance, I have laryngitis, so I'll do the best I can to keep my voice up. We are asking that this court affirm the decision and the sentence imposed by the trial court for Mr. Prentice Smith because he was not denied a speedy trial. The court did not err in denying the motion to sever. His convictions were supported by the weight of the evidence, and the trial court complied with the statute for imposing a consecutive sentence. Getting right into the speedy trial issue, I just want to say at the outset, there's no, to me, such a thing as a garden variety rate. Every one of these 4 rapes was distinct, but similar in the fact that these were 4 women walking alone in Akron that were picked up by a man that either offered them a ride or offered them, according to the testimony, when they were suffering from addiction or engaged in prostitution to support themselves. There was a conversation about sex for money, but there was never any payment, and the sex was taken against their will in a violent manner, that all 4 of them have suffered emotional distress all these years later. And part of the delay in the prosecution was the fact that it took until 2018 for us to get that DNA evidence and match to the 2011 case and the 2 2015 cases. So Mr. Smith has played a part in the reason why there was a delay in the prosecution. Then we have COVID, which none of us could have anticipated, and none of us even looking back can fairly really judge how the administrative judges in any of these courts handle these orders. But we do have tolling events, as Your Honor pointed out, from the governor and from the Supreme Court, and there is no dispute in the briefs or what transpired in the transcripts with regard to the tolling that occurred at least from March until July by the governor. And then the tolling orders, if you take a look at the 3 that were looked at and ruled on by this court to be able to be taken judicial notice of, and there obviously were more of them. But every month, the administrative judge put out a decision that was 13 to 14 pages long, and very carefully and meticulously, and I want to say really with an abundance of caution, because none of us knew how this would play out. And I know I can't speak for all the judges and the prosecutors and the defense attorneys in Summit County or the state of Ohio or anywhere else, but I can confidently say, based on our ethics, that we all want to ensure that constitutional rights to speedy trial are met, and everybody was very cautious about the fact that we had to do these continuances.
Let me just ask you, the administrative order was put out, so going now to not the statewide one, the
Right.
individual local ones. Did that specifically indicate that the speedy trial deadline was told for cases?
So what the decision said, so it outlined all of the declaration, state of emergency, all those things, cases that had come out and what it said. Then it said, Ohio Revised Code 294572 provides that the time can be extended. It cites to the 9th District Court of Appeals case, State v. Brewer, 2016, Ohio 5366, that says a trial court may continue a trial date without violating a defendant's right to speedy trial if the purpose and the length are reasonable. And then the court would suspend the trials. It was usually within a 1-month period. So to answer your question, it didn't say in black and white, and I hereby determine that everything is told, but it did cite to the statute that tolls time and to a case that allows the trial court to continue a matter without
Thank
stopping.
you. And then based upon Judge McCarty's orders, are you indicating that her decision to continue the trial was reasonable and not that the case was told?
Absolutely, that it was a reasonable continuance and that it would toll time based on that order. The other thing that I think is really important to point out is that the administrative orders were not challenged. So while Mr. Smith didn't agree to a continuance, and he objected to a continuance, in that transcript, when you read it, and I think it's only 16 or so pages, it starts out immediately, Mr. Smith does not want a continuance, that's clear. Judge McCarty didn't want a continuance, that's also clear. I mean, the matter was due to an order, an administrative order that is binding on the Court of Common Pleas judges. Mr. Smith's attorney could have challenged the administrative order.
Let's go back to the order, and I don't want to make you read it again.
No,
Thank you. But did it specifically say told, or did it say, did it give some discretion to Judge McCarty to continue the case if she felt it was necessary? I know eventually it says you can try a case if it fits in certain contingencies.
correct, so it would be the latter, you could grant the continuance, but it also said, so there's 2 parts to it, it also said jury trials are hereby suspended, which eradicated any ability for the common pleas court judges to go forward with the trial. unless they fit within the deadline. So the one that came out in July said within 7 days. There was no indication that this was within 7 days of the speedy trial. And then they changed as they went along. They got to the point where it would say, unless you have permission from the administrative judge. And one of these journal entries, I can't recall, I think it's the one from October 20th, 2020, specifically said, based on the administrative order, jury trials are suspended. It cites to 294572H, it cites to the Brewer case, and then it says, we can't proceed without administrative judge's permission, and we did not get her permission, she would not let us go forward. So truly, the common pleas court judge's hands were tied. Somebody, if they wanted to challenge the order, they needed to address that, right? File some type of an action to challenge the order itself, because the judges are bound by this administrative order, and that was not done here.
They're also bound by the revised code, and they're bound to try state cases within a certain amount of time. The gentleman was sitting in jail, and that clearly time had gone by, but for the administrative order.
Right, time had come by, and the state would find that based on the orders, the administrative orders, one, they were reasonable, and two, the court of common pleas, if they have an order that says you cannot go forward, suspending all the jury trials, they don't have a way to go around that.
Have any other counties dealt with this issue yet, or other courts of appeals that you have seen?
There are other decisions out there in other courts of appeals and federal cases that have said that it is permissible based on health orders to grant continuances. I know there were some recent cases out of 5th and the 8th District, detailed reasons for continuance. We talked about the ongoing global pandemic. They talk about Attorney General opinions that can suspend trials to prevent spread of the coronavirus, consistent with state and federal speedy trial obligations. The Ohio Supreme Court held judges have authority to continue cases on a case-by-case basis without violating speedy trial requirements, and continuing trial because of the pandemic state of emergency being reasonable. That's in a 7th District case that cites to the 5th District.
Thank you.
So there is case law that supports it, and I know looking back now, maybe we say, how long should it go on, or how long should it have gone on, but we did not know what we know now, and I don't know how much we actually do know now about the spread of the coronavirus. So the orders are very detailed. The state contends that the only time that's chargeable was the 13 days between the day after the date of the arrest, and then when the defendant asked for discovery, it was 13 days, which is a triple count, which adds up to 39. Everything else, when you look through it, was based on the orders that were requests of the defendant. So the really heart of this case, I think, is this issue of the order that came out on September 16th, 2020. It would have been the middle of 3 orders that were based on the administrative COVID orders. And it does say, by agreement of the parties, it's kind of underlined in the order, but that order, if you take, first of all, the parties did agree to the date. They did ultimately agree to October 19, 2020. Opposing counsel would agree with that. That was the date that was agreed on. So she does say, the judge does say, the trial in this case is rescheduled for 10/19 at 8:30 by agreement of the parties. That is true. They did agree to that date. He objected to a continuance, but he did agree to that date. But she notes the pandemic, the health risk, and the miscellaneous orders in that entry. So the idea that there's an error in the entry, I think that's a red herring. Also, as Attorney Kudici points out, court does speak through its journal entries. If there was truly an issue with the way it was worded, they could have had that addressed in the trial court. This journal entry is from September of 2020. There was certainly enough time to address it. But in my opinion, it's an accurate entry. It says that there was a continuance. It says that the new date is rescheduled by agreement. And truly, that is the date they agreed to. Noting that, of course, there was still an objection. So in this case, and when you get to the further later continuances, appellant concedes that everything after December 30th, 2020 were based on his continuances, his not being available, his attorney not being available. So the only area that there's any confusion, and I don't think it's confusion either, but you could have any issue at all would be the September 2020 entry, that entry still cites to the pandemic, the miscellaneous order, the need to keep health and safety and accurately states what the next hearing date was. It also states that there is time not to be charged to the state pursuant to 294572H. So everything that needed to be addressed in the journal entry is addressed by the trial court, and trial courts were doing the best they could to preserve the record to reflect the reasons for these COVID continuances. So based on that, we would ask that this court find that there was no violation of speedy trial. With regard to the severance that was requested, the law favors joinder. In this case, it was in the defendant's obligation to assert under criminal rule 14 that he was prejudiced or that there was sufficient information why there should be a severance and that the court abuses discretion. And the defendant cannot do that in this case. We would have been able to introduce, and he's only taking issue, by the way, with the 2011 incident, which was the one with the firearm, and he took the victim to the field. That was his first offense that we know of in this string of 4 rapes. So he used a firearm the first time. He got the woman into the car, took her to a field, raped her. There was, a tussle. Her belongings were found outside the vehicle, just like she said they were. She was visibly upset. She says there was no conversation about sex for money. So I would object to the characterization as the victim in the 2011 incident as
On the
having.
2011 case, certainly in that case, there's an entirely new charge, the gun specifications, not in
Yes.
the other cases.
Yes.
Isn't that new charge sufficient to make it prejudicial joinder? Because now there's some other issues the jury's hearing about that didn't occur in the other cases to make it different.
So I would argue the burden is on the defendant to show that there was prejudice. So just to say that you had a gun in one of these 4 times you raped women who were walking alone and you took them to an isolated area, I think a jury is sophisticated enough to find that the gun was only used in the one case and not the other 4. I don't think that makes it different enough to say that there was prejudice. Plus, it's his burden to show there was prejudice, and all he says is, well, clearly there was prejudice. It colored the whole trial. I think what colored the whole trial is the fact that each of these victims had the courage after all of these years to come forward and to say, this man raped me after he picked me up on a road and offered either to help me or to, maybe to engage in sex, but then took from me something that I did not agree to. And they all had the fortitude to do that. And his DNA was found, was a match to all of them. So his idea of what happened was that it was consensual sex. And
It's running low on time. I appreciate your answer on that. Thank you.
No, I'm glad you.
I have a question about assignment of number 4.
Yes.
And the argument regarding whether or not Judge McCarty made the specific findings at the sentencing hearing regarding the consecutive sentences.
Right.
Do you concede that she did not make the requirement at the hearing, or to your position that her statements were sufficient to meet the findings?
The state would contend that her statements were sufficient to meet the findings. They're clearly not word for word, but the law does not require that they're word for word. She did go through and talk about the fact that there were 4 victims, which is showing that there's more than one, occurrences. And then she talks about how great the harm is and that it's emotional harm and that they are still harmed by it. She specifically said it was egregious, the worst of the cases that she has seen. So those comply with 20 C14B of the consecutive sentence statute. And the case law specifically says it does not have to be word for word. Her journal entry is accurate word for word. Defense acknowledges that. So based on the entire reading of the journal entry, it is clear that the judge looked at the necessary factors that are required to impose a consecutive sentence, articulated the basis for it, even though she did not use a word for word analysis of the statute. And with that, I am out of time. I apologize again for my voice, and if there are no other questions, I would rest on my brief. Thank you very much.
Thank you, counsel.
Thank you, Your Honor. There is some orders that there are no remedies, okay? We know this. There was no remedy to fight the administrative law order. What would happen if the court, let's say a trial judge would call a jury, what would happen then? I don't know, the deputies coming in? I don't know. The objection is the remedy. You know what the remedy is? Right here today is the remedy for objecting to that order. Now, look, when I said this is a classic rape, the distinction from removing that gun is that takes it out of the classic rape. It's notably dissimilar. Look at it, Your Honor, look at the record in this case. You have a different location, not isolated, no wall, back seat, one pant leg, dramatically different, and it sets a tone. And you know what's important? It produces unfair bias in the jury by setting that tone, an escalated emotional reaction. My client's constitutional rights were defeated, they were violated, and that's why this case is so important. For a precedent to be set about speedy trial relative to let's blame it on the pandemic, I'm asking you to dismiss this case on a speedy trial and or remand it on the severance issue due to unfair prejudice. Last time I say, how do you prove prejudice?
Counsel, thank you very much for your argument today. Thank you both for your presentations. The court will take the matter under advisement. We will issue a written decision, which will be mailed by the clerk to all parties to this appeal on the date that the decision is released. You can also find it on the Ohio Supreme Court website. Thank you again.